This is the New York City and New York State related property tax bill that wants to kill S7000A. And I think we should read it very slowly and very carefully. So let's listen.
State of New York, 10,600. In Assembly, June 20th, 2024. Introduced by Committee on Rules Redents and referred to the Committee on Real Property Taxation. ANAC.
I don't know why it skips the parentheses, but we have to thank this member of Assembly Rakumar, right, which is connected with Eric Adams, according to the gossip.
ANACT to amend the real property tax law.
That's an act. I don't know why the reader reads it as ACT. Maybe it's because it's capital. But it's an act to amend the real property tax law.
ANACT to amend the real property tax law in relation to abolishing the class share system in certain cities, and to repeal certain provisions of such law relating thereto, to amend the real property tax law in relation to a homestead exemption. To amend the real property tax law in relation to a circuit breaker tax abatement, to amend the real property law and the real property tax law in relation to the assessment of residential cooperative, condominium, and rental property.
That's very important. It's changing the way co-ops and condos are handled. And let's just keep listening.
And to repeal certain provisions of the real property tax law relating thereto, to amend the administrative code of the City of New York in relation to cooperative housing corporations, and to repeal certain provisions of the real property tax law in relation to a partial tax abatement for residential real property held in the cooperative or condominium form of ownership, and to amend the administrative code of the City of New York and the real property tax law in relation to the determination of fair market value. The people of the State of New York, represented in Senate and Assembly, do enact as follows. 1. Section 1. This act shall be known and may be cited as the 52 Borough Fair Property Tax Act. 3. Section 2. This act enacts into law components of legislation necessary for the implementation of New York City property tax reform.
Yeah, they call it 5 Borough Fair Property Tax Act, but it's going to mess up North Brooklyn, which is not fair. You can call it whatever you want.
1. Section 1. This act shall be known and may be cited as the 52 Borough Fair Property Tax Act. 3. Section 2. This act enacts into law components of legislation necessary for the implementation of New York City property tax reform. Each component 5 is wholly contained within a part identified as Parts A through F. The 6th effective date for each particular provision contained within such Part 7 is set forth in the last section of such part. Any provision in any 8th section contained within a part, including the effective date of the 9th part, which makes a reference to a section of this act, when used in connection with that particular component, shall be deemed to mean an 11 refer to the corresponding section of the part in which it is found. 12. Section 4 of this act sets forth the general effective date of this 13 act. Explanation. Matter in is new. Matter in brackets italics is old law to be omitted. LBD 1516003-4. A. 10,600. 2. 1. Part A. 2. Section 1. Subdivision 1 of Section 1802 of the Real Property Tax Law 3 is amended by adding a new paragraph Class 1A to read as follows. For Class 1A, in a city with a population of 1 million or more 5. All 1, 2 and 3 family residential real property. Include 6. In such dwellings used in part for non-residential purposes but 7. Which are used primarily for residential purposes, including 8. Property held in cooperative or condominium forms of ownership, 9. And provided that, notwithstanding the provisions of paragraph 10 of subdivision 12 of section 102 of this 11 chapter, a mobile home or a trailer shall not be classified 12 within this class unless it is owner-occupied and separately 13. Assessed. And residential real property consisting of 114. Family house structures owned by the occupant, situated on land 15. held in cooperative ownership by owner-occupiers, and all 16. Vacant land other than such land in the borough of Manhattan 17. 10. Provided that any such vacant land which is not zoned Resi 18. Dential must be situated immediately adjacent to property 19. Improved with a residential structure as defined in subpara 20. Graphs and of this paragraph. Be owned by the same owner 21. As such immediately adjacent residential property immediately 22. Prior to and since January 1, 1989, and have a total area not 23. Exceeding 10,000 square feet. And located in the borough of 24. Manhattan north of or adjacent to the north side of 110th Street 25. Provided such vacant land was classified within this class on 26. The assessment roll with a taxable status date of January 5, 27, 2008 and the owner of such land has entered into a recorded 28. Agreement with a governmental entity on or before December 31, 29. 2008 requiring construction of housing affordable to persons or 30. Families of low income in accordance with the provisions of the 31. Private Housing Finance Law. And all residential real Prop 32. Birdie consisting of 4 10-unit rental dwellings. Notwithstand 33. In the foregoing, such vacant land shall be classified accord 34. Into its use on the assessment roll with a taxable status date 35. Immediately following commencement of construction, provided 36. Further, that construction pursuant to an approved plan for 37. Affordable housing shall have commenced no later than December 38. 31. 20.
Did you hear that? This law is so specific to some particular person and property. This is outrageous that they have this hard-coded in law. We'd have to look up what property they're talking about here. This is some particular property in North Manhattan. Look at this. Why don't we just make the law specific? Why don't we just say, John Jacob Astor property on blah, blah, blah is exempted because John Jacob Astor is very important. Unbelievable. This is just unbelievable that we have. Why do we need these types of things? Let's just spell it out. This is the guy who's getting a kickback favoritism or whatever it is. And of course, it all has to do with, with public housing. Yeah.
31, 2010, 39, Section 2. Paragraph Class 1 of Subdivision 1 of Section 1802 of the Real 40 Property Tax Law, as amended by Chapter 332 of the Laws of 2008, is 41 amended to read as follows. 42 Class 1. Outside a city with a population of 1 million or more 43. All 1, 2 and 3 family residential real property 44. Including such dwellings used in part for non-residential 45. Purposes but which are used primarily for residential purposes 46. Except such property held in cooperative or condominium forms of 47. Ownership other than property defined in subparagraphs 48. And of this paragraph and property which contains number 49. More than 3 dwelling units held in condominium form of 50. Ownership in which was classified within this class on a Privy 51. House assessment roll, and provided that, notwithstanding the 52. Provisions of paragraph of subdivision 12 of section 153. 102 of this chapter. A mobile home or a trailer shall 54. Not be classified within this class unless it is owner-occupied 55. And separately assessed, and residential real property not. A. 10,600. 3. 1. More than 3 stories in height held in condominium form of 2. Ownership, provided that no dwelling unit therein previously was 3. On an assessment roll as a dwelling unit in other than condom and 4. IUM form of ownership. And residential real property 5. Consisting of 1 family house structures owned by the occupant 6. Situated on land held in cooperative ownership by owner-occupy 7. ERS, provided that such house structures and land constitute Tooted bungalow colonies in existence prior to 1909. 40. And the land is held in cooperative ownership for 10. The sole purpose of maintaining one-family residences for 11. Members' own use, and all vacant land located within a 12. Special assessing unit which is a city other than such land 13. Closing square bracket comma. Provided that any such vacant land in the borough.
It seems to skip the stuff that's in red. It'd be nice if it would skip the line numbers, but I think this has something to do with bungalows and things like Breezy Point and Sea Breeze and things like that. It'd be nice if people would be clear what are they talking about?
Provided that any such vacant land in the borough of Manhattan 14, which is not zoned residential, must be situated immediately 15. Adjacento property improved with a residential structure is 16. Defined in subparagraphs and of this paragraph. B owned 17. By the same owner as such immediately adjacent residential Prop 18. Bertie immediately prior to and since January 1st, 1989, and have a 19. Total area not exceeding 10,000 square feet. And located 20. In the borough of Manhattan north of or adjacento the north 20.
So this part is being taken out? Unbelievable.
In the borough of Manhattan north of or adjacento the north 21. Side of 110th Street provided such vacant land was classified 22. Within this class on the assessment roll with a taxable status 23. Date of January 5, 2008 and the owner of such land has entered 24. Into a recorded agreement with a governmental entity honor 25. Before December 31, 2008.
It'd be nice if this change would be put side by side. They just scratch out a giant section and put in a new section. It seems like the same section. We'd have to side by side see what just happened. Unbelievable.
Before December 31, 2008 requiring construction of housing 26. Affordable to persons or families of low income in accordance 27. With the provisions of the private housing finance law.
This
not
is
with
all
28.
Removed.
Standing the foregoing, such vacant land shall be classified 29. According to its use on the assessment roll with a taxable 30. Status date immediately following commencement of construction, 31. Provided further, that construction pursuant to an approved Plan 32. For affordable housing shall commence no later than December 31st, 33. And all vacant land located within a special assess 2010, 34. In unit which is not a city. Provided that such vacant land 35. Which is not zoned residential must be situated immediately 36. Adjacento real property defined in subparagraph. Or 37. Of this paragraph and be owned by the same person or persons 38. Who own the real property defined in such subparagraph in 39. Immediately prior to and since January 1st, 2003, 40 Section 3. The real property tax law is amended by adding a new Section 411803C to read as follows, 42 Section 1803C. Real property tax rates in a city of 1 million or more 43 during the phase-in period. 1. Beginning in the first year of the phase 44 in period pursuant to subdivision 7 of Section 1805-45 of this article. The legislative body of the assessing unit shall levy 46 annual taxes at such rates that the revenue projected is no more than 47.1% greater than the revenue of the previous year. And that 48 result in all properties in each property class contributing the same 49% of gross levy as the previous year, irrespective of their 50 classification in the previous year. Thereafter, any change in annual 51 tax rates must retain the same ratio among class rates for the duration 52 of the phase-in period. 53.2. Beginning with the first year following the phase-in period pursue 54 and to subdivision 7 of Section 1805 of this Art. 55 CLE, the Commissioner of Finance shall conduct a ratio study, in accord 56 ants with the most recent standard on ratio studies from A. 10,600. 4. one international association of assessing officers, to determine the effective tax rates of all property classes and recommend any change in their 3 ratio. 4.3. In the first year following the phase-in period pursuant to subdivision 7 of Section 1805 of this article, the 6th legislative body shall set annual tax rates for each property class in 7 proportion to its share of the total fair market value of all real property as entered on the most recent final assessment roll. Thereafter, 9. Any change in annual tax rates must retain the same ratio among Class 10 rates until the publication of a new ratio study pursuant to subdivision 11(2) of this section, whereupon the legislative body may alter the ratio 12 of annual tax rates for the coming year in consultation with such study. 13.
So what is this saying? That the this is, who is this person here? The person that's doing this. Beginning, it says the real property tax rate. The important part seemed to be who does it. The legislative body, it says the legislative body of the assessing unit shall levy annual taxes. Legislative body, which I'm not sure who they're referring to there, but it does say beginning the article, the Commissioner of Finance. So the Commissioner of Finance, I believe they're referring to the New York City Commissioner of Finance, not the New York State. So let's continue. This is just a mess.
13. Section 4. Subdivision of Section 1801 of the Real Property Tax Law, as 14 added by Chapter 1057 of the Laws of 1981, is amended to read as 15 follows. 16. Special Assessing Unit means an assessing unit with a population 17 of 1 million or more. Which is not a city. 18. Section 5. Subdivision of Section 1801 of the Real Property Tax Law, as 19 amended by Chapter 191 of the Laws of 2001, is amended to read as 20 follows. 21. Base proportion means either, for a special assessing unit 22 which is not a city, the proportion of the
what does that mean, which is not a city? Somebody's got to explain this so-called law proposal. They already say it's enacted, but it's not enacted. Special assessing unit, which means an assessing unit with a population of 1 million or more, which is not a city. So it appears that S7000A now applies to some virtual place that's not a city and has a population of 1 million or more. Well, there are none like that. Who knows? What are they talking about?
The proportion of the taxable assessed value of 23 real property which each class constituted of the total taxable assessed 24 value of all real property A centered on the final assessment roll 25 completed and filed in calendar year 1981 of such 26 special assessing unit or on.
It sounds like they're trying to delete the base proportion part. Unbelievable.
The part of that assessment roll applicable 27 to a portion of the special assessing unit, except that for town and 28 county special districts not included within the definition of portion. 29. The applicable roll shall be that which was completed and filed in 30 calendar year 2001. Or for a special assessing unit 31. The proportion of the taxable assessed value of real which is a city. 32. Property which each class constituted of the total taxable assessed 33 value of all real property is entered on the final assessment roll 34 completed and filed in calendar year 1984. And 35 is adjusted to account for properties exempt under Section 43658 of this chapter to the extent such properties are 37 taxable for education purposes, provided, however, that the taxable 38 assessed value of real property subject to a transition assessment 39 pursuant to subdivision 3 of section 1805 of this 40 article shall be determined from the lesser of the transition assessment 41 or actual assessment. 42. Section 6. Paragraph of subdivision 1 of section 1803B of the Real 43 Property Tax Law is repealed. 44. Section 7. Subdivision 2 of section 305 of the Real Property Tax Law, as 45 added by Chapter 1057 of the Laws of 1981, is amended to read as 46 follows. 472.
I don't think we want things repealed. I think we have to be very careful here.
42. Section 6. Paragraph of Subdivision 1 of Section 1803B of the Real 43 Property Tax Law is repealed. 44. Section 7. Subdivision 2 of Section 305 of the Real Property Tax Law, as 45 added by Chapter 1057 of the Laws of 1981, is amended to read as 46 follows. 472. All real property in each assessing unit shall be assessed at a 48 uniform percentage of value, except that, if the 49 Administrative Code of a city with a population of 1 million or more 50 permitted, prior to January 1, 1981. A Class 51 Sci-Fi assessment standard, such standard shall govern unless such City 52 by local law shall elect to be governed by the provisions of this 53. Closing square bracket dot. Section in a city with a population of 1 million or more, all real 54 property in each assessing unit shall be assessed at 100% 55.
There's the problem right there. 100% market value. So this has no caps. We're all dependent on whatever the Department of Finance says with their little robot saying that your house is worth 5 million, 10 million, even though you didn't sell it. It's unrealized gains, and where in the world do we tax on unrealized gains? Nobody taxes on unrealized gains. That would mean that you might have to sell your house in order to pay your property tax. That's ridiculous.
Section in a city with a population of 1 million or more, all real 54 property in each assessing unit shall be assessed at 100% 55 of its fair market value. A. 10,006.
We're going to pause here because this is just so outrageous. We're only at page 5, and it's just going on. And really, when these things are proposed, somebody, maybe this person, this member of the assembly, should come and show their knowledge of it, because these things are not written by these members of the assembly, it appears. It's just written by unknown, unnamed people, and people should be able to question the law while it's being processed, right? If we can't have examples in law, and we don't know the effect of the law, and no one knows the effect to themselves, then why do we go through this reading process then if we don't know the effect? I've actually heard people say, well, they don't know what the effect is until it's actually enacted. Well, that's not right. In this day and age, we should be able to figure out the effect of a law and see if it's good or bad. Imagine if you ran a system like that where, we'll just run it, see what happens. The train crashed. Oh, that's not good. Let's just try something else. Let's see. Maybe if we put the engine inside the cabin where the people are sleeping, maybe that's better. No, it killed all the people. Oh, it's not good. Oh, yeah. Let's try something else. Let's put the engine underneath the bed where the people are sleeping, and see. Oh no, it burned them to death. Someone could have said, well, if you put the engine underneath where people are sleeping, they're gonna die. Let's not try that case, right? Because we use our, what we call our brain. Anyway, peace out. This is worse than I thought. S7000A killer, and the summary is there's no limits. You see right what it says. It says 100% assessment. Well, who decides what's 100% assessment? Who decides what's market value? You don't decide. Peace out.